Massachusetts gun laws are under review. This after a Supreme Court ruling nearly 2 weeks ago is trickling down into other states and changing how gun licenses are permitted.
Western Mass News reporter Paris Dunford joins us live to break down what this means for people here in the Bay State. Paris?
Chris, Mary, the Attorney General's office just released new guidance for local law enforcement officials when they consider a license to carry application. The biggest change is people applying no longer have to provide a good reason for why they want a gun. On June 23rd, the Supreme Court announced their decision in the case of New York State Rifle and Pistol versus Bruen. This ruling strikes down a New York gun control law, which required people to have a good reason to want to carry a firearm.
I think it was a terrible decision, and it is going to have impacts in Massachusetts because we have a similar type of law.
In their decision, the Supreme Court cited Massachusetts' strict gun laws, and now some of those laws are changing. Attorney General Maura Healey released an advisory to licensing officials. It reads, quote, "Licensing authorities should seize enforcement of the good reason provision of the license to carry statute in response to Bruen. Authorities should no longer deny or impose restrictions on a license to carry because the applicant lacks a sufficiently good reason to carry a firearm. An applicant who is neither a prohibited person or unsuitable must be issued an unrestricted license to carry." But one local law enforcement official tells Western Mass News that the reason someone wants to have a license to carry isn't weighed all that much in their decision.
It's on the application. The application, the state application asks what is the reason, and I think that it's still on there, but it's not something that we generally factor into our determination whether or not you're going to get a license or not.
Instead, they look at the person's suitability to own a weapon. Now, store manager of Guns Incorporated in West Springfield, Zachary Cretion, tells us this change in legislation might encourage more people to go apply for a license to carry.
I think that the good reason clause kind of prevented people just because they didn't know if they had enough proof for reason of carry. Now, without that clause being there, it gives them the open availability to come in and apply.
And some may argue that the removal of this good reason clause could lead to people purchasing guns for the wrong reasons. But Cretion doesn't believe that will be the case.
They're going to hide it. If they're trying to get a firearm, they're going to get it however they want to. So they wouldn't put down a negligent reason on their application to begin with.
Now, the Attorney General says licensing agencies can still ask someone why they are wanting to get a license to carry, but they aren't permitted to make their decision on the person's suitability based on that reason alone. Reporting live in studio, Paris Dunford for Western Mass News.
Paris,